Does your license need saving? Do the wise thing. Call Wiseman Lawyers. Does your license need saving? Do the wise thing. Call Wiseman Lawyers. Don't face that court alone. Let the Wiseman team get you back on the road. Does your license need saving? Do the wise thing. Call the Wiseman team at Wiseman Lawyers.
Today I'm at Tully Magistrates Court, about 2 hours south of Cairns. Two clients today. First was charged with repeat drug driving, second with repeat drink driving. Firstly, on the drug driving, they were charged with relevant drug present. There's two types of drug driving. One is that you've simply got it in your system but you're no longer under the influence. That's called relevant drug present. And the other one is under the influence of a drug, meaning you're high on drugs. Two different charges with their own penalties. Again, my client was with the lesser one today, but what aggravated was it was their third of this type within the last 5 years, specifically the last bit over 18 months. So third relevant drug present in a very short time frame. Worst case is a lifetime loss of licence, mandatory minimum 6 months. So my job was to get it as close to that as I could. Other client, repeat drink driving. The previous was extremely old, and it was a low range offence this time, 0.063. Ordinarily, it's difficult, if not impossible, to try to get no conviction recorded when you've got previous. But given what this gent did for a living, I'm not going to go into details, but it was an organisation that has its own internal scrutiny and additional consequences to what happens at court. So in the real world, if you've got a conviction for drink driving, even multiple, at the end of the day, it's still a traffic offence. It's not a criminal offence, so the consequences are limited, and it can be difficult to convince a magistrate that there will be consequences for repeat drink driving if a conviction is recorded, because in the real world, or I should say the civilian world, there really are no substantive consequences, whereas in the role or organisation that this gent's in, because it's got its own disciplinary process, etc., there can be additional punishment above and beyond what the court gives, and if there's a recorded conviction, it aggravates it in the eyes of that organisation. So what I'm getting at is, while it was a job of getting the disqualification down as low as possible, primarily my job was to try to get no conviction recorded for that client. It was a reading of 0.063 because the previous was more than 5 years ago. The maximum was 9 months, mandatory minimum was 1 month. So my job for that gent was twofold: A, to try and get no conviction recorded for the reasons I've already outlined, and B, to get it as close to the minimum as I can. I asked both clients to complete a reformatory course. One of them did it, one of them didn't. The reformatory course can be done online. I won't go into the details now, but it educates you on the potential consequences of your actions, and magistrates do enjoy seeing that people have done it. Got both of them to get references based on a template we provide all of our clients. Got instructions prior to today, obviously, from both of them. Prepared my submissions. Flew up last night from Brisbane, our base. Drove down from Cairns this morning. Met the clients at court. Ran through procedure, what they can expect, etc. before going in. Basically, where am I? Don't really know my way around Tully, but in any event, with the first client, the repeat drug driving, as I said, technically it's a maximum lifetime, mandatory minimum 6 months. Fortunately, they live in town, work in town, but they've got kids, so getting them to and from school and sporting events, etc., will be difficult while they're without a licence. And ultimately I was able to persuade the magistrate to stick to the mandatory minimum of 6 months. So the minimum 6 months. So when you got two previous in the last 5 years, minimum 6 months, and that's what I was able to persuade the magistrate to give. With the other client, the one that had concerns about the recording of the conviction, I spoke at length about their background, their employment with the organisation that I'm alluding to, and the very real consequences of not only the offence, but the recording of a conviction, if there was to be one. Spoke on my feet for quite a while, and basically this person's family's not based in Tully, so he's almost like a FIFO worker, so travels up for work, goes back on when he can, etc. Short version is, I was successful in A, persuading the magistrate to give the mandatory minimum 1 month disqualification, so 1 month disqualification from today, and B, I was, notwithstanding that previous, able to persuade the magistrate not to record a conviction, so no conviction recorded. So first client, 6-month disqualification. There was convictions recorded given the history, and it would have been unreasonable to request otherwise. But the second client, 1 month disqualification, no conviction recorded. Both clients are very happy and particularly relieved, especially in the case of the no conviction recorded client. I'm Andrew Wiseman at Tully Magistrates Court. Thanks for watching. Hi, I'm Andrew Wiseman from Wiseman Lawyers, Queensland's only truly dedicated drug, alcohol and traffic offence law firm. If you face loss of licence, loss of vehicle imprisonment or anything in between at any court in Queensland, we can and will help you today. This is our specialty. This is all we do. Give us a call, 1300 947 352. I look forward to helping you resolve your issue today.